Welcome to the Minor Children Custody and Visitation video. This video is for people who are starting a divorce case and have minor children with their spouse. Please make sure you've watched the Starting a Divorce Case video first before watching this one. In this video, we will talk about the decisions you will have to make regarding your minor children throughout your divorce case. Minor children will always be included in the divorce case, so it's important you list all their information accurately. For your minor children, which means children under the age of 18, you will need to make 3 decisions regarding legal custody, physical custody, and the visitation schedule, also called parenting time. Please note that you are only including children with your spouse in these forms. If you have children from a previous relationship who were born before your marriage, they will not be part of this case unless your spouse legally adopted them. Our court takes domestic violence very seriously. We recognize that some cases, perhaps yours, may include issues of domestic violence, whether it takes the form of physical abuse, financial abuse, emotional or verbal abuse, controlling behaviors or threats regarding children and custody, or immigration issues. The moment of filing and serving court papers in any kind of proceeding can be one of the most dangerous points in an abusive or controlling relationship, and domestic violence victims are often unaware of that danger. We can help you seek the kind of help you may require to ensure your safety at this point and going forward, so do not hesitate to contact the Self-Help Center for assistance. Please be aware that the forms require that you list a mailing address. If you do not want the other party to know your address, then you can use a mailing address for a friend or family member. You can also list a P.O. box. It is okay to not use your own address as long as you can receive mail at the address you do list. While a mailing address is required, you are not required to list your phone number or email address. The first thing you'll need to decide is legal custody. This determines who will make important decisions for your children, such as where they will go to school and the type of medical care they receive. You have 3 options to choose from. You can ask that you make these decisions on your own, which would be sole legal custody to you. You can ask that the other parent make these decisions on their own, which would be sole legal custody to your spouse. Or you can ask that you make these decisions together, which would be joint legal custody to both of you. It's important to note that legal custody is what gives a parent the right to make decisions about the children. It does not force them to actually make them. The next thing to decide is physical custody, which is about where the children will live most of the time. Again, you have 3 choices. You will need to decide if they will live mainly with you, which would be sole physical custody to you, if they will live mainly with the other parent, which would be sole physical custody to your spouse, or if they will live partially with each of you, which would be joint physical custody to both of you. Physical and legal custody are 2 different things, so you do not need to choose the same type of custody arrangement for both. For example, you might choose sole physical custody for yourself and joint legal custody. This would mean the children live mainly with you, but you and the other parent make decisions for them together. Even if one parent has sole physical custody, in most situations, the court wants to see that the child is able to spend time with both parents. This means that the parent without physical custody is given some form of visitation. In order to do that, you'll have the opportunity to propose a parenting schedule, which is also called visitation, for when the children will be with each parent. Your schedule can be as strict or loose as you think is best to reduce conflict around your children. Even if you have a written schedule, it is okay for you and your spouse to agree to make minor changes to that schedule. But having a court-ordered schedule gives you a backup plan if you ever disagree. It's easier to have a clear and enforceable schedule from the start before conflicts come up. If you already know that it is very difficult to negotiate with the other parent, or that they may not follow your agreement, you'll want to make sure that your schedule is enforceable. That means that someone who has never spoken to you, like the police, can look at your schedule and figure out exactly where the kids are supposed to be at a given time. For example, 1 day a week or 3 weeks in the summer is not specific. Law enforcement won't know which day or which weeks, so they won't be able to enforce it. It would be better to say something specific, like every Wednesday from 4 p.m. to 8 p.m. Often, parents choose to alternate weekends, meaning they each have the kids every other weekend. However, saying alternate weekends in your court-ordered schedule is also unclear and unenforceable. Law enforcement won't go back months or years to try to figure out which weekend you started on in order to figure out whose weekend this one is. Even if you are just negotiating between yourselves without involving the police, alternate weekends can be problematic and confusing. Often, parents make agreements to exchange or rearrange weekends so that it's better for the children, but then later, when a disagreement arises, it is impossible for them to agree as to whose weekend it should be. The clearest schedule, if you're doing weekend visitations, is if you indicate that one of you will have the children on the first and third weekends of the month, or on the second and fourth weekends of the month. Anyone can look at a calendar for any month and any year and figure out whose weekend it is and who the children should be with. Most of the time, this arrangement will be very similar to alternating weekends. Some months, although only 2 or 3 per year, will have a 5th weekend. You can specify who gets the children when a 5th weekend does come up, or you can leave it blank on your forms and assume that the custodial parent will keep the children on those weekends. If you and your spouse cannot come to an agreement regarding custody and parenting time, you will be required by the court to attend mediation before the court will make long-term orders. The goal of mediation is for you and your spouse to work with a child development expert to come to an agreement. Don't feel forced to make an agreement, however. You always have the right to say that you want the judge to make the decision after you've done your best at mediation. If you are scared for your children to be alone with your spouse, you can ask for no visitation or for supervised visitation, but it will be your responsibility to show the court why this limitation is necessary. If you request supervised visitation, you will need to decide between a professional supervisor, such as a court-approved agency, or a non-professional supervisor, such as a relative or friend whom you trust. The supervisor must be present throughout the entire visit. The court might grant supervised or no visitation if your spouse has been physically violent or has physically or sexually abused either your child or another child. You will want to bring the judge any evidence that you have of these things happening. The court might also grant this request if your spouse has a serious drug, alcohol, or mental health problem that's dangerous to the children. You need to show the judge that there is truly a connection between their problem and the safety of the children. For example, if someone is driving drunk with the children in the car, the judge can see that they are at risk of physical injury. But if they drink only when the children are not around, or they used to drink in the past, the judge may find it difficult to see how that puts the children at risk now. Something that is not grounds for supervised visitation is that the other parent does not care for the children the way you do. The court expects that the other parent might parent differently and can learn parenting skills like diaper changing, for example, if there's a need. As part of the divorce judgment, the court can order child support. Child support is for food, clothing, and shelter for your child. It does not include sports, private school, or vacations. To make support orders, the court will need financial information from your family. Even if you are not going to ask for child support now, you can always ask the court to order it later. Contact the Self-Help Center for help with a request for order if you want child support to start before your divorce is finished. The local child support agency offers free services to parents and guardians to help them meet their responsibilities to their children. These are some of the services they provide. They can help you establish paternity for your child with a court order and can help you arrange for genetic testing when the child's father is in question. They also provide some assistance in locating parents. Specifically, if you don't know where the non-custodial parent is located, the local child support agency will try to find the parent to establish paternity for the child's father and or to establish, change, or enforce orders for child support. Once paternity is established, you can get help with getting a child support order based on each parent's income, timeshare, and other visitation. Most orders will also include a wage assignment, meaning that money will be withheld from the non-custodial parent's paycheck to pay child support. In certain situations, they can help you get a change in your court-ordered child support amount, which is called a modification. Your children have a right to health insurance coverage. They will work with you to make sure your children get the health insurance coverage they need if it is available at no cost or at a reasonable cost. The local child support agency has several ways to collect child support for your children, including withholding wages from paychecks, license suspensions, levies on property and bank accounts, and passport denials. Additionally, they can intercept other income and benefits, including state or federal income tax refunds, unemployment, workers' compensation, state disability benefits, and lottery winnings. Some of these enforcement actions are required by law. Others will be used depending on the facts of each case. California child support payments are collected and processed by the California State Disbursement Unit, or the SDU. Those receiving child support can choose to have payments deposited directly into a bank account or receive payments on an electronic payment card that can be used like a debit card. If you are making child support payments, you must consult with the local child support agency to confirm your eligibility to make child support payments electronically. As was described in the introductory video starting a divorce case, you may need to file a request for order if you need the court to make orders regarding your children soon. A request for order will schedule you a hearing within a couple of months where you can ask the judge for any custody, visitation, child support, or spousal support orders. If you do not feel the need to get orders on a faster timeline, you can wait until your divorce is finalized and the judge makes their orders at that time. But remember that this may be months or years from now, and in the meantime, there are no court orders regarding your children in place. There are a few other situations that might complicate your case. If you and your spouse have a child born before you got married, you need to make sure you ask for parentage to be established in your petition. When a child is born while you are married, the husband is automatically the father of the child. However, if you have a child who was born before you got married, you will need to legally establish that the husband is really the legal father. Let us know if this is an issue for you when you contact us to review your forms. Sometimes, while you and your spouse are still legally married, even though you may be separated, one of you may get pregnant or have a child with someone else. If the non-parental spouse is not legally disestablished as the child's parent, they are presumed to be the child's legal parent, even though they are not the biological parent. They can potentially be responsible for this child financially until adulthood. If this issue is brought to the court's attention properly and in time, the spouse can be disestablished as the parent of the child and replaced by the biological parent. It is extremely important that you contact the Self-Help Center and have your forms reviewed, or contact a private attorney if this is your case. If you have any questions about how to proceed or about your children's custody and visitation, please feel free to contact the Self-Help Center.